be entertained. That section has been validated by several Court of Appeal decisions as being a constitutional section. Very recently, the Administration of Criminal Justice Act, which was signed in May this year, also made provision proscribing interlocutory appeals in criminal matters that will necessitate a stay of proceedings. But notwithstanding these clear provisions, I think the issue that we should be bothered about is the deliberate serial abuse that arises when a counsel with knowledge of these provisions deliberately afflicts on the court an application to still hear a motion to stay the proceedings, knowing that it will not succeed, and goes further to prosecute an appeal based on a refusal by a lower court in the Court of Appeal and in the Supreme Court. And that is what we have seen in all the cases from Diarrhea and all the others. They end up in the Supreme Court after 6 or 7 years, only for the Supreme Court to angrily dismiss them and ask these individuals to go back to the court of first instance to stand their trial. It is the abuse, the deliberate abuse of the law that we should be bothered about. I think part of the problems we have too also has to do with the several rules that we keep bringing up, in an attempt to resolve what we perceive to be problems in the system. We keep bringing out new rules. We keep bringing out new rules. Let me give you a small example. The practice direction of the Federal High Court. It's an attempt to actually ensure that trials are fast-tracked. But in Section 3B, it says, on the date of the first arraignment, the prosecutor must produce the accused person in court. Now, let me just give you a small example. You have about 20 accused persons that are jointly charged. There's no way you can actually separate them. All they need to do is for one out of the 20 to be absent, and the trial is truncated. And he can easily get a medical report if he's a resourceful person from the best hospital in the country. The next adjourned date, another one comes, I'm not well. After that, another one comes, I'm not well. 2 years on the line, you are still dealing with people that are not well. So, whether we like it or not, we have practical challenges, and being the ingenious Nigerians that we are, we should find a way to also tackle these practical challenges. I think another problem also has to do with the issue of immunity against prosecution. I expect that politicians who are honest would on their own say, look, this immunity clause should go. It has become an albatross. And the reason why the immunity clause is the major problem is the principal offender may be the person that has the immunity. The people I call the sidekicks, or those who just assist, who are just accessories to the fact, may be available for prosecution. But as long as the principal offender is shielded, it makes no sense whatsoever for the prosecution to even go ahead. Makes no sense at all. I agree that most times the accusation is that it is the counsels that are the problem. It is not all the time. At times the courts are the problem. Why are the courts the problem? I'm sure a lot of you are aware of the inconsistent positions that have been adopted by our superior courts in the interpretation of Section 251 of the Constitution as it relates to the jurisdiction of state high courts in the prosecution of criminal offenses. You know, we have two decisions now from the Court of Appeal that are completely opposite of each other. One says in certain matters in the exclusive legislative list, even in criminal matters, the state high courts have no jurisdiction. That is the case of Erastus Akingbala against FRN. And the other decision in a Hindero against FRN says there is nowhere in the Constitution that exclusive jurisdiction under 251 is vested in the Federal High Court. Now, whether we like it or not, a lot of matters that have been decided previously are now likely to be subjects of appeal. And other related cases to that may not actually be in the same boat have now raised jurisdictional challenges to the continuation of other trials. Don't forget that you can raise the issue of jurisdiction at any point in time. And because of that, that is what we're seeing today. So the courts themselves need to clean up their act. We need to have a clear exposition of the law on a major issue like the interpretation of section 251 of the Constitution. It may be convenient for me today for 251 to be interpreted in a particular way, but not okay for me the next day if it is so interpreted. So it is important that that issue should be dealt with. People accuse the EFCC of not investigating properly before charging people to court. I agree, in some cases, they actually have those challenges. But don't forget that this is a country that expects too much from people and gives very little to those people. If you look at the investigation of James Ibori's case in England, it cost the British government £40 million just to investigate Ibori's case. Don't also forget that a substantial part of that investigation was done actually by EFCC. It was not done by the British police, but it still cost them £14 million to investigate Ibori. In that year, in 2013, the entire budget for EFCC, both overheads, investigation, fueling of vehicles and everything, was £47 million. This is an agency you expect to investigate 774 local government councils, 36 states of the Federation, the federal government of Nigeria, and the private sector. I think we are asking for too much. We are being absolutely unrealistic with ourselves. Investigation costs a lot of money. Unless you are ready to invest in it, you should not expect too much from it. You know, it is not a justification for the EFCC to also charge people to court without investigation. But it is part of the society that we live in. The moment they suspect that anybody is a thief, everybody says he should be charged the next day. And there is pressure on the agency on a daily basis. This man has not been charged. The Americans will investigate it for 3 years, very quietly, and wake up one day and charge you. But here, it's like the case of Jesus and Barabbas and Pontius Pilate. They said, Pontius Pilate said, I see no evidence against this man. I think he should go. The people said, no, we want blood. He must die. And he washed his hands. But there was no evidence against him. But he was still convicted. He was still sentenced. The sentence was still carried out. It's the same thing here. We like lynching people on our own without due process. And unless we depart from that attitude, some of the people we accuse of actually stealing money, it turns out that they really are not worth anything at the end of the day. Yeah, I'll just be rounding up now. There are just two issues that I want us to speak on too, just before I round up. One, I think the National Assembly is also not doing a lot. I think they are running away from key issues that they should address. For a very long time, there has been a bill, the Non-Conviction-Based Asset Confiscation Bill. It's there in the National Assembly. There's no intention to pass it. There's no incentive to pass it, because a lot of them may be victims if that bill is passed. That is a bill, is a law that exists in a lot of countries in the world today. Why is Nigeria an exception? So our representatives who want bribery, corruption, and related offenses to be dealt with in this country should be men and women enough to pass this bill so that the proper thing can be done. Once you recover assets from people, assets that they did not acquire legitimately, there will be no incentive for them to commit the offense. If you are not going to keep the process of crime, there will be no incentive for you to actually commit the offense. So that bill should be passed as quickly as possible. And I think the lives and the properties of witnesses in corruption cases should be protected. We don't have any witness protection program in this country. In fact, as at 2013, 19 key officers of the EFCC had been killed in the line of duty. There's nobody who is going to volunteer his life to serve this country if there's no assurance that this country will, in like manner, take necessary steps to protect such an individual in the discharge of his duty. I thank you for listening.
I think we can do better than that. Because we've gotten a lot of insights from the Leonard Silk, Godwin Obla, on the topic which we are dealing with, which is very germane. And he has highlighted challenges from the side of the prosecutors. He talked about the lack of political will. He talked about elements of these crimes which cuts across nations. And he also talked about interlocutory appeal. And of course, there was a divergence in the issue of political interlocutory appeal from the first speaker, Chris Uche, but there was a common ground on political will. There are many other things, but I think it's now convenient for us to hear from one of the bodies, agencies, charged with dealing with the issue of corruption, the EFCC. I will call on Ojobana Johnson, representing Ibrahim Lamrodi of the EFCC, to please give us your own perspective on this to help us to find strategies dealing with this cankerworm.
Good afternoon, participants, ladies and gentlemen. Permit me please to stand on the existing protocol. I have the singular honor to represent the executive chairman of the EFCC, who is unavoidably absent. And I want to say, before I present his position to this August gathering, my personal experience in the last 11, 12 years of the EFCC. I'm privileged to be a prosecutor for the EFCC, and I work fully with the EFCC in the last 12 years. Therefore, I have seen and I've participated in a lot of the corruption cases in the EFCC. I'm a very senior member of the legal department of the EFCC, so I've had the privilege of looking at virtually all the files that has to gone through EFCC, the one including governors and all the politically exposed persons that we have seen on papers and in the courts. And let me say this quickly, please permit me, that corruption is it's not just cancerous. I think it's the greatest killer disease in our nation. The cases I've had to, the file I've had to read on a daily basis in the last 12 years, and the trials I have to witness, the court system, I'm so afraid. And let me say this, that this August gathering, the MBA, the legal profession, if we don't do something very quickly and very fast, because without any doubt, I know that this gathering, the MBA, has what it takes to turn the tide of corruption. We can do it. Nigerian lawyers can do it. If we stay together, work together, and make up our minds, the people that have continued to impoverish our nation, they will think twice. Lawyers can do it. Let's do it together. Let me give you a piece of my chairman's remarks on these issues. Talking about adopting strategies for the speedy dispensation of corruption cases without considering the root causes of the delay, to my mind, is tantamount to cutting the branches of an unwanted tree and leaving the roots. It is therefore imperative for me to consider the root causes of delay in the speedy dispensation of corruption cases before proposing strategies to deal with the problem. One of them, like the learned Senior Advocate of Nigeria, both of them mentioned interlocutory applications. We can't run away from it. It's there. It's all over the place. This is the most monstrous of all the causes of delay in the speedy dispensation of corruption cases. A former Chief Justice of Nigeria, Justice Dahiru Mustafa, at the second annual conference on the reform of criminal justice administration held in Asaba, June 2012, had this to say. Please, help me to listen to his comments. The former CJN, he said this. Almost every criminal trial, especially on serious charges of corruption, is now preceded by endless objections and applications to quash charges. This effectively stalls the main proceedings and results in the misuse of judicial time and resources. Some judges, wittingly or unwittingly, aid this process by failing in their duty to be firmly in control of criminal proceedings in their courts and allowing these gimmicks to go unabated. I cannot agree more. These interlocutory applications, which more often than not, sometimes very frivolous, are usually taken on appeal upon refusal from the High Court, through the Court of Appeal to the Supreme Court. The appeals are coupled with applications for stay of proceedings pending their determination, which regrettably are granted in most cases. Needless saying that all these are calculated to cause delay in order to frustrate the cases, because even the counsel making the applications know most of the times that they are frivolous. This is what has bedeviled most cases commenced by the EFCC against former state governors since 2007, all of which, as we talk today in this meeting, are at different stages of their journeys to and from the Supreme Court, all on interlocutory issues. Recently, while commenting on the establishment of the Presidential Advisory Committee Against Corruption, this person is not a lawyer, is not a judge, is not a member of our profession, is merely a public commentator. A renowned public commentator, Mr. Haruna Idris of Radio Nigeria, on the 17th of August, this month, had this to say. Although the EFCC statutes expressly provide that its trials should be conducted with dispatch and given accelerated hearing, the nation's antiquated and colonial era procedural regimes and rules make that utterly impossible. Add this to the Shylock defense lawyers, some of whom are learned silks, who take advantage of the rules to file interlocutory appeals that inevitably drag on for many years, thereby leaving the substantive matter unattended. One can see the present danger if it is not urgently reformed. Since inception, both the EFCC and the ICPC have arraigned about 70 prominent politicians and public officials for corruption, but regrettably, less than a tenth of that number has been convicted. He said further, this is sad. For without convictions, there is complete absence of the doctrine of deterrence for future offenders. That was the comment by a public commentator. Another issue I want to address quickly before I round up is the issue of congestion. Congestion of cases in our courts and slow pace of court proceedings occasioned by insufficient number of judges. Nigerian, as we are today, there are over 45,000 lawyers. We have fewer judges in our nation's courts. The courts themselves are fewer. And if nothing is done to address this, the cases we file in court, corruption cases, including other matters, will continue to suffer. A former justice of the Supreme Court, Nnameka Agu, as he then was, had this to say. He said, in Nigeria, the situation is different. Cost lists are very long, and the machinery for disposal of cases is less expeditious. Parties to a case are at the mercy of courts in that, except in cases in which accelerated hearing is granted for every special reason, cases must take their turn. If we are going to make progress with corruption cases, Section 19, Subsection 3 of the EFCC Act provides that the courts can grant special concession when corruption cases are filed before their courts. The courts are not having the courage to effectively implement the provisions of these laws. Another issue that has bedeviled corruption cases is the issue of trial de novo. We all know that. A case is tried by a judge. I did a case recently in Akure Federal High Court Division. We had concluded trials, and the matter was adjourned for us to file and address the court, final addresses. And that same month that we were supposed to adopt, when we came to court, by the time we stayed in court for like 2 hours, the registrar told us that he's sorry to inform us that the judge has since retired. Final address, and we have to, and this case, the new judge there cannot try this case. By our rules, the case has to go back again for us to call fresh witnesses. Some of the witnesses that we used in that case, some students who were defrauded by a man who claimed to be running a university. Some students, we have to keep them in hotels, protect them. We can't even find them anymore. So that case is as good as lost. Frequent transfer of judges in the federal high courts. Judges hardly stay in their divisions in Nigeria for more than maybe sometime, even a year or 2 years, they are moved away. And when they are moved away, these cases have to start all at the same time. Our position is that if the federal high court judges are allowed to stay for a longer period, 3-4 years, I'm sure they'll be able to conclude their cases. We only hope that the courts will be able to courageously enforce the provisions of our laws. My learned Sikh mentioned before Section 40 of the EFCC Act that deals with interlocutor applications. The Court of Appeal, in a recent case of Adeboye versus FRN, stated it clearly that that provision of the law is not against the Constitution, rather is an offshoot of it, and that provision should be firmly enforced by our courts. We hope that the judges will have the courage to continue to enforce the laws. The EFCC Act also provided for designation of judges to try EFCC matters. As we talk today, if we file a case in the courts now, that provision of the EFCC Act, I don't think they are even looking at it because the cases are assigned to every judge in the division, every judge. And as long as the cases are assigned to every judge, these cases are subsumed into a long list of cases that these judges have before them. And in the process, the cases are continually delayed. The practice direction, like Malene Sikh said, is there, but we hope that it will be reviewed to solve a greater problem. Let me round up by saying this, that on behalf of the executive chairman, we are hoping and praying that the cases that we handle, like Malene Sikh said, are corruption cases, which will go in a long way to serve as deterrent to others. If we don't join hands together as stakeholders and build a society that is free of corruption, the impact of it is not only on us who are here today. It's a generational problem. And we hope that we will look forward together as stakeholders to do what we call joint responsibility. Let's fight this fight together. Thank you.
Thank you, Johnson. You've done very well. And I want to assure you that the whole purpose of this session is to help the EFCC and other agencies in moving the cases forward. So I think that members here present will say amen to your prayer while we have other discussions. Let me invite Oke Igbudu from the ICPC to give us that institution's own perspective.
Thank you, Mr. Chairman of Session. Permit me to stand on the already established protocol. I want to begin by saying that
I'm sorry to cut you. It's just that we have about 25 minutes more for this session. So please, you just bear with me that you might not have the whole 15 minutes. So we're going to reduce it to 7.
that is unfair. But all the same, I will go, first of all, the topic is exciting. It talks about adopting strategies for speedy disposition of corruption cases. When I got this topic, first of all, let us start by looking at what is speedy. I tried to look at dictionary definition of speedy. It says characterized by rapid motion, accomplished or arrived at without delay, prompt. Now, the right to a speedy trial is guaranteed. The right to a speedy trial is guaranteed by a constitution, but rather refers to a length of time set by law in which a case must go to court. That is under section 35, 36, says the case must go to court within 24 hours in a criminal trial or 48 hours, where there is no nearby court. The disposition of a case, however, refers to its final adjudication, and there is no statutory limit as to the length of time a trial may take under our law. I tried to do a search and find out what happens in other jurisdictions. I discovered that in other developing countries like Philippines, they have, a speedy trial act. In the Philippine case of Gonzalez and Sandy Gaba, the Supreme Court of Philippines held that the right to a speedy disposition of a case, like that of a speedy trial, is deemed violated when the proceedings are attended by vexatious, capricious, and oppressive delays, or when unjustified postponement of trials are asked for and secured, or long period of time is allowed to elapse without the party having his case tried. Equally applicable is the balancing test used to determine whether a defendant has been denied a speedy trial or a speedy disposition of his case, for that matter. I permit me to say that this right should not really be given only to the defendants. But unfortunately in Nigeria, it is the defendant that doesn't want his case to be tried. The right to a speedy trial is also guaranteed by the U.S. Constitution. The state of Wisconsin law provided that a victim, just like other states, the Speedy Trial Act is a federal law in the U.S., passed in 1974, and is applicable all over the states of the U.S. Now, the state of Wisconsin law provided that a victim has the right to speedy disposition of his case in which he or she is involved. The Wisconsin Crime Board, Victim Board, has interpreted case as including all phases of the criminal justice process, beginning with the initial report of crime. As I said, the U.S. Constitution, the Fifth Amendment to the U.S. Constitution guarantees, the right to a speedy trial. The Fifth Amendment and the Speedy Trial Act set forth rights related to criminal prosecution. The Fifth Amendment stipulates that in all criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall be committed. The Speedy Trial Act of 1974 establishes time limits for completing the various steps of a federal criminal prosecution. Time limits. Now, in deciding whether a defendant's right to a speedy trial has been violated, the U.S. Supreme Court laid a 4-part test, balancing test, for determining whether the right has been violated. And these 4 tests are the length of delay, the reason for a delay, the time and manner in which the defendant has asserted his right, and the degree of prejudice to the defendant which the delay has caused. Now, unfortunately, under Nigerian law, apart from section 35 and section 36 that talks about when the person should be taken to court, there is no provision for speedy trial. Nigerian law does not seem to entitle a person to speedy trial. Section 36(1) says, in the determination of his civil rights and obligations, including any question or determination by or against any government authority, a person shall be entitled to a fair hearing within a reasonable time. What is a reasonable time? There is no decision on that. By a court or other tribunal established by law or constituted in such a manner to secure its independence and impartiality. Now, in the Second Republic, an attempt was made to set time limits for hearing election cases. However, the Nigerian Supreme Court came down heavily against those provisions in the case of Unongo and Apako, and declared the Electoral Act of 1982 as an unwarranted interference in judicial powers. However, following the long delay in hearing of cases, electoral cases, in the P2B case, Fewenya and Doni, Areboshola and Onyola, an attempt has been made again to re-establish, the time limits by the amended 1999 Constitution. Permit me to state an attempt to set time limits for hearing of corruption cases through the Corrupt Practices Act of 2000 under Section 26(3) was struck down by the Supreme Court in Attorney General Ondo and Attorney General Federation. So, if we are going to have speedy trials, it should not be left to the courts and the judges. I think a time has come for us to have a speedy trial act in Nigeria. Please, I don't know there's the PowerPoint. I kept the PowerPoint. Sorry. There's a table I just in my presentation. A survey by Center for Social Legal Studies. They try to look at how long it takes to have cases in Nigeria tried. Interlocutory appeals and speedy disposition cases. And the tables, in one case here, Adewumi took 11 years and 4 years and 11 months. In Akban, 1 year. Akimbola case, 2 years. In Anima Shaun and the state. And I'm talking about corruption cases, just ordinary cases. 5 years and 4 months, all based on interlocutory appeals. In the case of Georgia and Federal Republic of 2 months. And so on and so forth. In one of our cases, after we have concluded the investigation, we wrote a report to we wrote a letter of invitation to the suspect to appear in court, and he went to court. That case has been in court just on a mere invitation for the past 12 years. He has gone up to Supreme Court, and he's still in Supreme Court. Just to appear and make a statement before the commission, he went to court. I've been asked to round up, so I'm going to go to the suggestions. Now, what are the reasons for these delays in courts? There are so many delays, so many reasons. Application to quash charge, challenge to court jurisdiction, objection to admissibility of commission statements. So prominent in our, most of our cases. Once you, trial within trial, once an accused person's statement has been tendered, even the statement that was made, confidential statements, you have several cases going on appeal over admissibility of confidential statement. Application to stay proceedings, interlocutory appeals, accusation of bias against judges, challenge to the act and its constitutionality. Heavy court dockets, judges going on conferences, transfer retirement, assignment of judges to election tribunals, sometimes for years. Frivolous application for adjournments, absconding accused persons. Finally, I want to say that if we are going to have a speedy trial in Nigeria or speedy disposition of cases, then there's a need to restrict interlocutory appeals and motion for stay of proceedings, either through a constitutional process or practice directions. I'm happy that the NBA has is beginning to show interest in matters of corruption. And I think it's important because the NBA played a part in the fight for independence. Sorry, the lawyers played a part in the fight for independence. They played a role in the fight against military rule. I think the time has come for the NBA, to show interest in, not just lip service, but serious, interest in fight against corruption. Because when people lose interest in the court system, what you're going to have is a resort to self-help and lawlessness. Thank you very much.
Thank you very much. Please, let's thank him in a more better way. Thank you. Well, I think he's just spoke well and talked about speedy trial. I think he calls for the enactment of the Speedy Trial Act to supplement the Constitution so that we can have these matters done speedily. I think this session today, today's program, is about the second time we're having for that call. So I think we better note that. And while I call my sister, who normally does her things in brief, to also give us our own perspective in brief. You're welcome. May.
Honorable members of the bench, distinguished guests, distinguished senior colleagues, and fellow members of the bar. It gives me great pleasure to be here today to speak on the NBA Anti-Corruption Commission's work and the NBA's effort at ridding corruption in the practice of law. This topic that I would like to talk about is close to each person in this room. The NBA has made great strides in this area and indeed will do more in coming years. So here I'll take opportunity to highlight briefly the work the NBA is doing in this area. In response to the challenges faced by anti-corruption agencies in the fight against corruption, the Nigerian Bar Association's National Executive Committee in 2012 established the Anticorruption Commission to assist the NBA to take an informed position on corruption and to collaborate with appropriate agencies and organizations to duly imbibe best practices in order to effectively tackle endemic corruption issues within the bar and in Nigeria as a whole. There have been so far 2 anti-corruption agencies, one in 2012 to 2014, chaired by Yusuf Ali SAN, and the current Anti-Corruption Commission, chaired by Dr. Theo Osanapo SAN, with 9 others, including my good self. In order to achieve the success in the fight against corruption at the bar, both the Ali and Osanapo commissions have had a number of key guiding terms of reference, namely to help set up anti-corruption committees in all branches of the NBA across Nigeria, to set and maintain the highest standards of conduct at the bar, to develop and facilitate policy dialogue and anti-corruption training courses, workshops for stakeholders in the fight against corruption, to develop feedback mechanisms from anti-corruption agencies and the general public, to establish formal and transparent mechanisms for applying anti-bribery and corruption prevention measures, to monitor and investigate allegations of corruption leveled against members of the bar and the bench, to identify practitioners who carry out corrupt activities in the legal profession and justice system, and forward their names and evidence of corrupt practices to the relevant agencies for prompt action and prosecution, to identify corrupt practices and factors or circumstances that promote corruption in the bar and bench, to do all things necessary to ensure a corruption-free society. So far, the first Anti-Corruption Commission had a conference in 2014, and we have had a conference this year in June. We have also in 2014, there was also set up 15 anti-corruption committees in different parts of Nigeria, and this year we have set up another 12 agencies. In fulfillment of the mandate, we have had very, very good conferences that were very well attended, and we had interesting speakers, and a lot of new ideas and initiatives have been brought up. So far, since I have a very short time to speak, I will go straight ahead and discuss what the NBA is doing at the moment. But before I go any further, papers that were presented at the last conference, we have had them bound, and we are going to put them before the Anti-Corruption Committee set up by the President. And one of our speakers the last time in June was Professor Bolaji Owasonoye, who is now on that committee and is the Executive Secretary. So we know that a lot of recommendations are going to be hopefully accepted. Future plans. The Commission is working assiduously to explore new and better ways of promoting the NBA's anti-corruption drive through advocacy, social media, workshops and conferences, and will participate actively in this year's forthcoming International Anti-Corruption Day on the 9th of December. I will now go on to talk about the NBA and the discipline of lawyers. The NBA has set up a specific disciplinary unit within the Legal Research Development Directorate. And so far, we have about 780 active petitions at this point in time. And whenever the disciplinary panel, we have different, NBA has different disciplinary panels located in each of the 6 geopolitical zones in the country to investigate matters before them. And upon conclusion of such investigations, the disciplinary panels send the report of their findings to the disciplinary unit, where thereafter a prima facie case of professional misconduct is established. The same is forwarded to the Legal Practitioners Disciplinary Committee. We also have the whistleblowing at the bar and the bench. With regards to the NBA, what the NBA is doing at this point in time is to improve delivery, justice delivery. The NBA has set up an anonymous committee of lawyers with an unknown membership across the country for specific purpose of monitoring the adjudication of matters in various courts all over Nigeria. The anonymous committee members will attend specific courtrooms where a judge has been identified as dilatory or incompetent or indolent. They will be observed and record court proceedings by alternating attendance for 2 weeks, and in some cases apply for court judgments in order to further observe courtroom practices. After the 2 weeks, each member of the anonymous committee attending the court will complete and send a report on the courtroom to the NBA with a written statement on oath stating any official complaints. The NBA President, Mr. Augustin Alege, has said that the initiative is taken with the intention of policing the judiciary, but as a practical step to sanitize the practice of the law by the bar. He admitted that the initiative was not a definite way of searching and weeding out corruption, especially since no one has access to bank account details of judicial officers. However, he expressed his belief that the initiative is an immediate way of checking incompetence and graft. Another step the NBA has taken is the establishment of the Judicial Ombudsman at the NBA Secretariat in Abuja. Mr. Alege has assured judges they may report lawyers who act unethically to the NBA, where they will be disciplined accordingly by the NBA's disciplinary mechanism. Mr. Alege also commended the Chief Justice of Nigeria for its stance against publication of books by sitting members. The consolidated effort by the bar and the bench to internally sanitize the legal profession is one that Mr. Alege considers imperative, and thus these initiatives, though not absolute, have become necessary. The bar must rise up to the challenge and take the lead in advocacy that would help influence, promote, and implement policy making that will exterminate impunity in not just the bar and the bench, but in the country as a whole. Thank you very much.
Please, let's clap for her because she kept to time, and I said so at the beginning. You've not disappointed me, May. Thank you very much. And for the last speaker, that's Mr. Christopher Ogundari. Please, can you just speak to your paper in the next 5 minutes so that we can have opportunity to take questions and other contributions from our members on the floor.
Mr. Chairman, I'm most grateful. I would like to thank everybody for being here, and I would also like to crave the indulgence of the chairman to adopt the protocol hitherto set by Leonard Silk. I would also like to adopt the statement so aptly stated by Godwin Obla, SAN, the disclaimer which he made, as the comments which I will be uttering here are strictly speaking mine and do not reflect both my principal as well as the judiciary. Now, I'm basically here to talk about one of the strategies that I believe should be considered now to overcome the delay in the dispensation of justice, especially as regards corruption cases. Now, for quite a while now, we have been listening to various speakers raising points as to the problems that we have with the current laws that are in our books, as well as the practice directions. For all the best intentions of all these laws, what we have found is there is still delay on the ground. And the fact is that unless we start to adopt and to think out of the box, we will not be able to certainly overcome those delays. I would like to point out that the representative of the ICPC is right in a certain respect that there needs to be perhaps a Speedy Trials Act. But in the absence of a Speedy Trials Act, what we have are the laws that we have at the moment, and I quite frankly think they suffice for us to get cases moving along, so far as we show the necessary will to do justice rather than just to look at the nebulous interests of our clients. And so for that purpose, the Administration of Criminal Justice Act, Section 270, speaks about plea bargaining. And I believe Mr. Godwin Obla, well, I believe it was, yes, himself, mentioned Section 270 in passing. I want to go into Section 270, and this is the vexed issue of plea bargaining. Now, in a country where we're fast becoming culturally linked with corruption, indeed, if you look online at the Urban Dictionary, you will find that there is a definition for 419, and I wish to quote that definition. The name 419 actually said as 419 derives from the section of the Nigerian law that con artistry and fraud comes under, hence the association with Nigerians. That is my own emphasis. I think the Chief Justice of Kenya was right yesterday when he says when a habit stays for more than a year, it becomes cultural. I think we need to look at the issue of corruption and think out of the box, and that is where the plea bargaining provisions of Section 270 comes in. I know that a lot of people will be thinking, plea bargaining, you know, that concept, it's only for big men. It's used as a way to get politically exposed persons and connected persons off the hook, as it says. And in that respect, I would like to quote the Executive Secretary of the Anti-Corruption Network, now Senator Dino Melaye, who caustically opined after a case that was particularly egregious, I won't name the case, that we once again call for the eradication of plea bargain. It is evil, nonsensical, archaic, and detrimental to our avowed fight against corruption. We advocate the China option of capital punishment for corruption, in which the family of the convicted and executed persons pay the bill for execution. Now, that shows obviously the level of, should I say, blood baiting that is related to the trial of corruption cases. We are all frustrated with corruption, but the problem is, how do we solve not only delay in corruption cases, but also in other cases in general? Now, the speakers here have been quick to point out, you know, the problems, but not enough discussion has gone into practical steps. Now, I know the practice directions that are currently on the books are supposed to be able to speed up, in theory, the prosecution of corruption and serious crimes. But unfortunately, obviously, we all know that the courts as they stand, as well as the problems and the limitations of the criminal justice system, puts pay to the best intentions of those laws. So for as long as there is lack of communication between the prisons and the courts, we are always, and between the police, prosecution, and all the stakeholders, we're always going to have a problem. Now, the Administration of Criminal Justice Act, 2015, obviously building on the EFCC Act Section 14, as well as the Lagos State Equivalent Administration of Criminal Justice Law, prescribes plea bargaining. And plea bargaining, simply put, I think I would like to read from my paper on this one. Plea bargaining, simply put, is an agreement between an accused person and prosecutor in which the accused person agrees to plead guilty to some or all the charges against them in exchange for concessions from the prosecutors. Now, we've seen this in a host of cases. I will not delve into those cases. Suffice it to say, most of the high-profile corruption cases, from those to dealing with the managing directors up until the politically exposed persons, have to a certain extent been resolved by plea bargaining. And before we all start to, criticize these decisions, and some of them should be criticized, what we must remember is that these were made at the time with a view to recovery. And a key thing that hasn't been pointed out is in corruption cases, as victims of corruption, which we Nigerian taxpayers are, the first thing we should be looking at is the recovery of the assets and, of course, making good that which has been lost, rather than us, trying to look for 1,000 years in prison or whatever harsh punishment we feel. And to a certain extent, the plea bargaining under the Administration of Criminal Justice Act will also enable for matters to be speeded up from the intention that I see on the Act. Let me quote extensively from that section, but obviously paraphrasing because of the exigencies of time. The main purpose of the Act itself includes promoting efficient management of the criminal justice institutions and speedy dispensation of justice, protecting the society from crime, and protecting the rights and interests of both the defendant and the victim. Now, in Nigeria, we've tended to be skewed towards the victim, forgetting that the defendant, who is languishing in custody for 2, 3, 4 years, whilst his matter is in court, is also actually maybe suffering some harm. I would be interested to find out from our persons at the EFCC and ICPC, who I believe is the ICPC, who mentioned the length of certain cases where the defendants in those cases in custody. And in some cases, they may be in custody, depending on the threshold. In some cases, they may be on bail. Nevertheless, the delay in the dispensation of justice overall is affected when we refuse to consider solutions such as plea bargaining. I know that in 2003, the federal courts in the United States dispensed of 75,000 criminal cases. 75,000, that's probably more than we have in total in Nigeria. And in dispensing of that, 95% were by plea bargaining. And the reason for this is there's usually some evidence, but perhaps not strong enough for you to be able to go to full trial. And in such cases, a defendant who knows that there's evidence against him may actually wish to opt for plea bargaining so they can get the matter over and done with as quickly as possible. Now, Section 270 enables us to do this, whilst at the same time permitting us to ensure that speedy dispensation of justice is of course, upheld. Unfortunately, because of time, like I said, I cannot go deep into the sections, but suffice it to say that the problem of corruption is one that requires new solutions, combined multifaceted strategies, and better coordination in the justice sector. And I think where we have a simplified system of administration of criminal justice, the likelihood is that cases will move along much faster. And I think plea bargaining is one of those solutions that may or may not, as the case may be, depending on whether or not it is used or abused, may actually help us to resolve issues of delay in the dispensation of justice. Thank you very much, Mr. Chairman.
Thank you very much, Christopher Ogundari. I know that time was not on our side, and you had to summarize. But for the benefit of us that are here seated, please note that his paper, he titled his paper, Analyzing the Provisions of Plea Bargaining under the Administration of Criminal Justice 2015, and its likely impact on the trial of corruption and other cases. It has been uploaded in the MBA's website for this conference, so you can go there and read his detailed presentation. Once again, I want to thank you for your contribution, particularly on the issue of plea bargaining. And one question perhaps we'll come to later is whether in this country plea bargaining will serve as a deterrent. Just keep that in view. And before I call for questions or comments from the audience, may I invite the chairman of the committee the chairman of the Anti-Corruption Committee, TCS Osanapo SAN. I think he has some comments to make regarding this session.
Thank you. On behalf of the Commission, the perspectives given by the very distinguished speakers in this session have actually provided a better and further insights that will assist the Commission in terms of its advocacy and also the engagement we need to make with the bodies involved with anti-corruption exercise in this country. I must also say that we felt very strongly that it is important for us to have benefit of thoughts of people who have proven experience in this direction, and this session has actually provided that. Even though our task is a very tedious one, we'll put all these things into consideration as we begin to discharge our assignment. Thank you.
Okay, thank you. Now that we are done with that, we also want to hear from the audience. There are many hands up. I wish I could take all of you. Okay. So I think I'm going to give opportunity to some seniors and also to some juniors, taking into consideration all parts of the hall. Can I start then from my right? I know that OCG Okosha has spoken this morning, but no, you said prayer this morning. So I think I can allow you to make your comment because you've been quite forthright on this subject. OCG Okosha SAN, former president, Nigerian Bar Association.
Thank you, Mr. Chairman. Distinguished colleagues, I thank the presenters for their very insightful presentations. But I didn't hear any of them say anything about the capacity of our present anti-corruption agencies to investigate, to properly and thoroughly investigate cases and bring those cases to courts. Because my only thinking on this is that the reason why these cases are not succeeding is because they don't have the capacity to investigate and present those cases. What is the point of filing 153 charges against one man and you cannot even prove one? And the relevant example is somebody was acquitted and discharged in Nigeria. The same person pleaded guilty in England because he saw the evidence against him. So I don't know whether you consider, my distinguished panelists, whether the institutions that we have are sufficiently equipped to bring these cases to court and to successfully secure convictions. Thank you.
Thank you very much, Mr. Osiju Okosha, your contribution. I also, personally speaking, I think I also feel the same way as you do. I've taken one from that side. I think it's better I go to this side to take one. And perhaps, where's with the microphone? Okay, let me take a hand from the back. Yes. Yes. The gentleman standing, I think with a brown tie. Yes.
Thank you, Mr. Moderator. My name is S. Wanko from Abakaliki branch. I would just want to make an input, sir, particularly on the issue of de novo, which one of the panelists raised. We can all see that our session here is being recorded on video camera. Why can't our court sessions be video recorded so that if, for instance, a judge is transferred, there wouldn't be the need for an incoming judge, because the usual reason is that the incoming judge didn't have any opportunity of viewing the demeanor of witnesses. But I'm thinking that if the sessions were videotaped, just as this session is being videotaped, any incoming judge can quickly flip through the video that is presented to him or her and can fast-track, or maybe we do away entirely with the de novo process so that, as the panelists said, a matter that had gotten to the address stage, the judge was either elevated or transferred, and all of a sudden, or retired, they said the case is going to be started de novo. That's my only two input. Thank you very much.
Thank you for that contribution. I want to be gender sensitive. So is there the lady? Yes. Okay. Let me take you from the front, the lady from the front.
Mr. Chairman, panelists, and my lords, the name is Oloyede Olamide from Osun State. I've always had a different view to the fight against corruption. 4 years ago, there was a law reform conference here in Abuja, in which I contributed, and I told the anti-graft agencies present on that day, I think it was Mrs. Waziri that was in charge of EFCC. I said, why instead of letting people steal our billions, then you use another billion to chase them? Why don't you simply prevent them? Because even if you get the money back, it doesn't go back. Whether it's taken from my state, we don't see it anymore. The vacuum is there. The vacuum created by the money that has been taken can no longer be filled by your prosecuting and recovering that probably ends up with the EFCC or the federal government. I don't know. I think we can't continue to do things the same way and expect a different result. I think we need to change our attitude and we need to change our tactics. I personally feel that it is an issue of enlightened self-interest. If everybody does not join hands to fight corruption, as Mr. President has said, corruption will kill us if we don't kill corruption. So this was the point I advanced and canvassed then is that if EFCC, for instance, we publish local government, this is what you got for this month, this is what it is meant for. You can start fighting corruption from the point of budgeting. I was an head of department, and I found it ridiculous when you budget, you pay somebody's salary, 18,000 a month. Then you keep 100,000 for that particular person with the chief registrar. You give the chief registrar the power to decide whether to expend that 100,000 for that person or go away with it and do something else. Why don't you give that 100 person, if he's a director, this is what you want to do, pay it to that person. So even from the point of budgeting, you nip corruption in the board. Thank you very much.
Thank you very much. I think I come back to this side. And sorry, I can't see very well, but I think that's Yusuf Ali. Okay. I can't tell you to sit down now, so just go on with your contribution.
Thank you very much, Mr. Chairman. Thank you, Mr. Chairman. You are too dark. That's the point. Mr. Chairman, you raised a poster, which I think I want to answer before I make my comment. The poster was, with plea bargaining, there will be no deterrence shown or message of deterrence sent. With respect, I don't think it is right. You see, the fact of conviction is a blot. Plea bargaining does not mean the man will just pay the money and he will go. He's pleading guilty to the offense with the hope that he will be given lesser punishment. So guilt itself is enough brush of shame. So that is the deterrence. And if you look at our constitution, anybody that is found guilty of any act of corruption at all is barred from public office at least for 10 years in the constitution. I think that is sufficient. You see, my own stake, why I support plea bargaining is simple. and part of it was expressed by the last speaker. Those who commit this high net worth of corruption are too well connected and too well, they have too much resources. And OCJ had hit something on the nail, on the head. And that has been my position in various fora. The anti-corruption agencies are not adequately empowered. They don't have the kind of human and material resources necessary to investigate some of these high net worth, very sophisticated crimes. It's only the enlightened, educated people who do corruption at that level. And they have the connections to make sure that the investigation is never properly done. Number two, if it is done at all, they have the resources to engage the best brains to defend them. Number three, there is uncertainty generally in litigation anywhere in the world. Because we are not the judge. You can't say because, oh, we saw him doing this, then this must be the result. So, because of those uncertainties, it's better for the state because our interest is our money. If the man goes to jail for 1,000 years, the money doesn't come back to us. So, recovery of the money should be the first consideration. And I think it is necessary. The only thing we should do is to ensure that there is transparency in the implementation of Section 270. Let's make sure that we have people who are there who are human beings in the real sense of it, who have conscience. And I think that is the bottom line. Thank you very much, Mr. Chairman.
Okay, thank you very much. Unfortunately, I will wish to take more. I will have wished to take more, but I've been told that the next session, the time is here for them, and they're already here in the hall. And it's an important topic which we would like to drive, but it would be unfair if I do not call on members of the panel to just have the last bite before I summarize, and I think we'll bring the session to a close. I think key to this one, I will want to call the EFCC representative, Johnson, if you have anything to add, because I think some of the points that have been made apparently are directed to your institution and perhaps the ICPC. But I'm sure that if you give an answer to this, just on the points made, so that we don't go over again issues that have not been raised.
I think on the issue of lack of resources that the national advocate just said, that's obvious, and I think everybody knows that. Notwithstanding the dwindling resources of the federal government, we are also canvassing for greater funding for the ACAs, anti-corruption agencies. Like Leonard Six said, the British government investigated a matter we had already investigated. The Ibori case, we provided them with virtually 80% of the evidence that they needed for that case. And they still used £14 million to do their own investigation and take the case to court. So funding is one of the main areas that this government will be able to if the fight against corruption is uppermost in their minds, then more funding for the ACAs. I think that will be very much appreciated now and in the days ahead.
Also, Obla, I think you have an input again to make.
Yes, I think I'm more interested in the suggestion put forward by Mr. Nwankwo about video recording of proceedings that can be used later. I am sure that most of us are aware that most of the jurisdictions abroad actually use video links now to even try prisoners who are security threats from their cells in the prison instead of actually bringing them to court. So if we can do that here and completely obviate the necessity of embarking on de novo trials, I think it will be very, very helpful. I was a victim of a de novo trial. You recall that in the Akingbola case, we had actually concluded the entire trial and had reserved to adopt our written addresses before the judge was elevated to the Court of Appeal, necessitating a de novo trial, wasting absolutely 3 years of intensive prosecution and trial.
On this de novo trial, let me just add quickly that it also it depends on counsel involved and the Chief Judge as well. I have a matter, Chief Nia Kitola and myself, we're handling. The judge was transferred, and we didn't have any objection to his continuing with the matter, and we are still proceeding. So I think it all depends on how that cooperation, to make the system work. And quickly, I just want to also add on the issue of the plea bargaining as a deterrent, the conviction. We all also remember the case where, despite the conviction, there was a presidential pardon. So some of these things go to weaken the system. The mere fact of conviction will not deter the type of Nigerians we have. So that calls for the need for attitudinal change. That's the only thing that will help us come out of this quagmire.
Thank you. I don't think we have any other thing to say here. You have something to say quickly, please?
Unfortunately, I wasn't able to bring out the salient point from some of the lectures we had. But like, for example, Professor Bolaji Owosanoye did mention the fact that the Attorney General of the Federation should drive the crusade against corruption. And secondly, he also did mention that the EFCC, ICPC, they should be made more independent, that they should fall within the, they should be first line in charge on the Consolidated Revenue Fund, because funding is definitely very important, and so is their independence.
All right, thank you. I think we've done very well in this session, from contributions from the panelists, from suggestions made. We take home the point that the legal framework which we have been itemized, and also we find them workable, but will require some attitudinal change. And also, we also note why some of these matters do not work. It's because of the lack of political will. We'll take those points. We've also noted the requirement and suggestion for us also to have the Speedy Trials Act. And on the practice aspect, as highlighted by Obla and Chris Uche, the reasons for delay, the interlocutory issues of interlocutory appeal, of course, the divergent points, and but we need to address that as an association, members, and also to note this. And I think it's a point which we can conveniently take under the rules of professional ethics. So the MBA will look at that, particularly the commission. And we've also noted the point about investigation. And the reason for that is that of funding. So there must be the political will to fund these agencies and to make them institutions that it truly should be in order to serve the purpose. And we think that these suggestions being made here will be taken appropriately so that it's not just coming here to talk, because I can see that the NBA is quite consistent with its discontent about corruption. And I want to thank everybody for participating actively in this session, and I wish all of us well in the remaining part of the day. Thank you very much.
Thank you, Chairman and panelists. You may leave the...
Have you discharged us?
Yes, you have been discharged. I'm not sure about acquitted, but you have been discharged.
No, we don't want acquitted. We are not on that right.
The next session, and the final session, is the session that has been presented by the Young Lawyers Forum of the Nigerian Bar Association. This is the session on generational shift and opportunities in emerging areas of legal practice. Can I first invite to this side of the hall President O.C.J. Okocha, Senior Advocate of Nigeria, past President, Nigerian Bar Association. where the red is. We have to lead discussions on this session the following speakers: Babatunde Fagbonlu, Senior Advocate of Nigeria; Nela Rabana, Senior Advocate of Nigeria; J.S. Okutekpa, Senior Advocate of Nigeria; Olumiwe Akiboro, past General Secretary; Uwa Ohiku from Jackson, Eti and Edu; Shenwa Bimbola; Linus Okeke, and Oniofok Luke from the Akwa Ibom State House of Assembly.
Chairman, every time I want to sit near you. Eh? I want to sit near my sister. Eh? I've been looking for my chair. I just scribble what I like to say. They don't tell me. They just took me unaware. I only did voice to them inside the group. Where did they?
Right. The purpose of this session, which is specially dedicated or seeks to focus on the situation of young lawyers, is as described in page 29 of the program. For the purpose of those that don't have the program, the rider to that session states that in an era where the public's ability to purchase legal services become more limited, where established lawyers are increasingly challenged to make a living, and where the legal system's resources are becoming overwhelmed, young lawyers in particular must adapt to these developments. Now, our panel of distinguished speakers will discuss new opportunities that exist in the traditional and non-traditional areas of legal practice. After I leave this podium, we'll have a brief statement by the Young Lawyers Forum. I believe the chairperson of that forum will come up and speak for 2 minutes about the activities of the forum. Now, at this session, we will also introduce or inaugurate, as we have written here, the Yusuf Ali Young Lawyers Advocates Prize, which is a prize endowed by Malam Yusuf Ali SEN to support brilliance at the level of the young advocates. It's one of the measures that Malam Ali has put in place to encourage young lawyers. So Malam Ali will also have 2 minutes to describe his prize. It will be inaugurated at this session, but I think the first presentation will be at the next annual general conference of the bar. So I see that we are far behind time, so to move quickly, I'll call on the chairperson of the Young Lawyers Forum to speak for 5 minutes before we now get into the proper discussion. So Young Lawyers Forum, who is the person speaking? Right.
All protocol duly observed, distinguished gentlemen of the bar. My name is Barbara Moson, the chairperson of the Young Lawyers Forum. It is my pleasure to welcome you all to this annual conference and the presentation of the Young Lawyers Forum. The Young Lawyers Forum of the NBA started during the tenure of the then president, Olusegun Bakoba, SAN, and since then the forum has grown to be very large. And we have a database of over 1,000 young lawyers who are our members. And we encourage young lawyers from 0 to 7 years at the bar to be part of this forum. After our inauguration in February, the forum has added an additional 154 members to its database. And the president, who has the interest of young lawyers at heart and the development of young lawyers, has given us an opportunity on this platform to discuss issues that are of interest to members who belong to this post-call category. And this year, we had the privilege of attending the section of Business Law Conference in Lagos, and we had our annual Young Lawyers Conference in Benin. Gentlemen, I welcome you once again to the section presented by the Young Lawyers Forum. Thank you.
Okay, is Malam Yusuf Ali here? No. Malam Yusuf Ali? Right. Mr. Chairman, you are now in control.
Distinguished speakers, distinguished audience, my dear colleagues. In those days at Great Ife, we had the chairman of our National Union of Rivers State Students, who was a non-executive chairman. And we had a secretary who was an executive secretary. Chairman would sit back and the secretary would speak for hours on end, at the end of which the chairman would say, the secretary has said all the basic things. So the colleagues who have spoken before me, Wale and Barbara, have said all the basic things. So we'll go directly into the presentation of the papers by the various panelists. Okewale, who was supposed to chair this session, is unavoidably absent. I hear he's stuck somewhere, but may get here soon. If he does, I will yield his seat to him. But I'll proceed immediately to invite the speakers to make their presentations as they are listed on page 29 of your booklets. I've been told to allocate 10 minutes to each of them. And when I calculated that there were 10 of them, that would amount to 70 minutes. And then we are supposed to have an interactive session where some may raise issues, make comments, and ask questions. If we can, in our presentations, distinguished speakers, shorten the time and bridge the time by yourselves, it would be deeply appreciated so that we may finish on time and have sufficient time to take comments and questions from the audience. This is an interesting topic for me, and I hope that we will not begin to hear again this persistent clamor of young lawyers that seniors should pay them more than they are paying them now. You are told that you should be innovative, use your qualifications, and do what you can as professionals, even though young lawyers, to help yourselves. So thank you for the opportunity. I will now invite the speakers in the order in which they are listed. Babatunde Fabuhundu, SAN of Aluko and Oyebode. Please welcome him with a round of applause.
He's not here. Good evening, ladies and gentlemen. Honorable Mr. Chairman, I'm here. Oh. Actually, I thought when Mr. Chairman was talking about juniors not disturbing seniors for money, it was because he saw me here and knew I was going to come to disturb him. But now I am going to talk about, in the context of the overall theme that's been set for this session, I'm going to be talking about developing individual competency in emerging areas of legal practice. Now, just reading the overall theme at page 29, I found it very interesting that it talked about what's evolving in the legal profession around the whole world. And I thought I should start my presentation by talking about a book that I stumbled on a number of years ago, written by a man called Richard Susskind. And it's a book which I think every one of us should read. The caption of the book, very dramatically, is "The End of Lawyers." And essentially his theme is that so much is changing in the world around us, that information and communication technology is changing so much around us that you are going to begin to see a lot of services that lawyers traditionally provide, being packaged into electronic devices and sold on a commercialized basis. And lawyers have to begin to think about how they can continue to be relevant in a world where information and communication technology is rapidly changing the whole nature of legal services and even the nature of the demand for legal services. I just said that as a background. Like I said, my topic is to talk about individual competencies and in emerging areas of legal practice. There are two main themes there. Emerging areas of legal practice, and secondly, individual competencies. Now, the background, of course, to what makes this subject very relevant in Nigeria today is the economic and political context in which we are talking. So, in terms of the economic outlook, in spite of all that's going on around the world, we expect there's going to continue to be interest in investing in Africa, and in particular in Nigeria. And of course, the traditional sectors in which investments take place: oil and gas, power, mining, infrastructure, telecoms, financial services. A lot has been happening in the oil and gas sector, which has an impact on the whole question of which areas in legal practice are going to be emerging, and what implications does that have for young lawyers. So we've seen a huge drop in the price of oil, which means that the revenue of the country is affected, and people are going to be looking at, government is going to be looking at other ways of raising revenue. which means there's going to be a huge amount of focus on taxation, and there's going to be a huge amount of focus on diversifying exports. Now, politically, all of us who are those who are at the session this morning would have seen a huge amount of focus on anti-corruption. That's going to be the major thrust of the current regime, and that opens up all sorts of opportunities in terms of white-collar crime, corruption, criminal law, and all whatnot. There was also, of course, anticipated the justice sector reform. Now, question then is, what is an emerging practice area? I define an emerging practice area in two terms. Applying, well, first of all, new areas of legal knowledge that never existed before. An example I would give, for instance, is information and communication technology law, and then regulatory risk and compliance. These are totally new areas of law that people had never really specialized on before. Then, for me, an emerging area of legal practice would also happen where you are applying existing knowledge to new demands. So something has happened in the context of your country, like in the context of the economy or the political framework, which means that a particular existing area of legal practice suddenly becomes resurgent. There wasn't much activity in that area of practice before, but all of a sudden, there's a huge demand for services in that area of legal practice. And the examples I will give would be tax law. Now, I mentioned earlier that there's going to be a shift in governments, where government looks to raise revenue, and taxation is going to be one of them. Now, that's a very classical example of where, existing knowledge, tax law has always existed, before, but there's going to be a resurgence of it because of the economic environment in which all of this is going on. So that's what an emerging legal practice area is in the context of my discussion. I will rush straight on to the question of individual competencies. Now, individual competencies is a concept that is known in human resources, particularly in the context of performance evaluation. Essentially, it is defined as the combination of observable and measurable knowledge, skills, and abilities, and personal attributes which contribute to enhanced employee performance and ultimately results in organizational success. There are three main types of competencies that human resource practitioners usually look out for. There's the personal skills, the professional and technical skills, and the entrepreneurial, leadership, and management skills. Now, traditionally, we have tended in the law school curriculum, in the universities, we've tended to focus to a large extent on the second one I mentioned, which is the professional and technical. But what we are beginning to see is that as things go on, there's going to be increasing demand for young lawyers and for practitioners to be able to exhibit very strong personal skills as well as entrepreneurship, leadership, and management skills. And so the question of individual competencies is quite a very relevant one. Why are individual competencies important to law firms? From a law firm management perspective, a law firm will be engaged in recruitment, will be engaged in training, will be engaged in performance evaluation. And in the context of all these three activities, it will have to develop a very good system for developing individual competencies in the associates that it hires. Like I said earlier, we are very familiar with the traditional competencies: knowledge, writing and drafting skills, logical and scientific reasoning, eloquent speaking for barristers, networking skills. But I will, in future, like I said, there's going to be a lot of emphasis on the personal skills and the entrepreneurial skills. We will begin to see the demands of clients in these emerging sectors that I will identify very soon.
They are as listed.
Yeah. The demands of clients will mean that lawyers have to focus on developing their skills in things like information technology, project management, innovation, due diligence, collaboration, something called emotional intelligence, and business sense and financial literacy. Increasingly, for instance, a lot of the work I do, I've found that I've had to have a basic knowledge of how a company's accounting and financial statements work. whether it's a balance sheet or the profit and loss account. And that's because increasingly a lot of practice areas tend to be very multidisciplinary. What are the new emerging areas? I will just briefly identify that before I round up. In the dispute resolution sector, that is litigation and arbitration, we have been seeing and will continue to see a good deal of activity in the oil and gas sector, disputes in joint venture, production sharing contracts, gas pricing disputes. We'll see a lot of tax litigation, like I said earlier, but we're going to also begin to see a lot of troubled assets, civil fraud and white-collar crime, regulatory disputes, environmental impact litigation, as communities continue to agitate for better deals from the oil companies, employment contracts, following the expansion in the jurisdiction of the industrial court, and then access to information and privacy laws. And on the transactional side, we will continue to see a good amount of activity in project finance and corporate finance, public-private partnerships, as there's going to continue to be a focus on developing infrastructure, information and communication technology, restructuring and insolvency, governance, risk, and compliance. What are the features of these emerging areas? Number one, they tend to be very cross-border. In other words, they involve different countries, players from different countries. Take a syndicated loan, a very complex syndicated loan arrangement, for instance, where banks are from America, from England, from Nigeria, financing a project that's going on in Nigeria. They tend to be multidisciplinary. They bring together all sorts of disciplines, not just lawyers, but financial consultants. They tend to be very complex, and they tend to be very information and communication technology driven. And these are the things that point the way in the direction of what types of skills young lawyers are going to have to start focusing on in order to be relevant to the evolution of legal practice. Thank you very much.
Tunde, thank you very much. You stayed within time. I will now call on Nella Andemewa Rabana, our dear colleague, to make her presentation. She's the senior advocate of Nigeria from Calabar, Lagos, and Abuja. And Adi Lorin.
Thank you, Mr. Chairman. Let me start by saying that it's always a pleasure having to speak to the young lawyers. And it's even a greater pleasure when one is participating in a forum that I hope will cause us to focus our attention on the sustainability and the relevance of our profession. As you know, lawyers are agents of change and social engineering. It is critical that whatever decision or career path you take, you bear in mind that you should be relevant at all times in society. Looking up, I know that the categories is either you're in private practice or you're in the public service. Now, generational shift, because the question you might ask, is there really a generational shift? And the answer is yes, there is. Why? Because there are, and for you to ascertain that in fact there is, I would like us to look at some of the factors that impact legal practice. Globalization, technology. Especially any young lawyer who is not IT savvy should be worried. The world, the changes are so frequent and so fundamental that if you're not part of a technology-driven practice, and if whether you're in private or private legal practice, you do not have a handle on technology, then the likelihood of you not excelling is very high. It is my belief that the the purpose for which this topic was chosen is for us to be able to position ourselves. Now I'm talking about the young lawyers. In the face of the changes that are occurring, one reality in Nigeria today is, as has been spoken if you were in the session earlier this morning, is the economic reality. It has impacted in such a way that young lawyers are challenged, not even all young lawyers, all lawyers, as a matter of fact, are feeling the impact because clients, for instance, are demanding more for less, and because of the development in technology, they have access to information, and so they expect much more. And if they are wanting you to work more for what they're paying, then that means you as a young lawyer have to be prepared to research, to develop yourself, and to be creative, because a lot depends on the individual. I looked particularly, because I don't want to repeat also some of the points that you have made, on the growth of practice areas and other related positions, and also on training. As the Nigerian economy evolves, certain practices have also evolved. Now, I don't know if I had mentioned earlier about globalization and the fact that borders have melted. And so you have more practices, private practice that is multi-jurisdictional. And the question is, you may belong to that, and if you do, then there are certain things that you have to be thinking about. I just read recently in Argentina where they're encouraging people to take a second language, particularly Chinese. Now, I wonder how many young lawyers have a second language. That is an added advantage. So in other words, when I'm talking about creativity, I'm talking about you looking at the reality and trying to locate and position yourself or enhance your opportunities so that you excel in the dynamic environment that we find ourselves. Indeed, the generational shift is affecting not only the quality of practice, but the areas. We all saw the hula baloo in the sports sector with FAA. How many lawyers have participated in that? How many young lawyers are interested in sports law? How many lawyers, because for a player to be bought or sold, as they say, or for the issue of doping, they must be represented by lawyers. We have good Nigerian footballers. In fact, I think in terms of sports, we're doing relatively well. How are lawyers positioning themselves, are the young lawyers positioning themselves in those areas? Copyright law, especially in the entertainment industry. How many lawyers are looking at those options? Conflict issues in e-commerce is critical. Today, in fact, most activities, transactions are done electronically. Are the young lawyers positioning themselves? Are they exposed to the kind of training that will enable them appreciate the issues that have arisen or are arising from internet networking and social networking is another area. I find that although we have spoken in the past on public interest and class action, especially as it relates to human rights issues, there are present issues that are recurring or have occurred. Displacement of persons, especially the issues in the northeast and northwest of Nigeria. Are there lawyers paying attention to those developments and seeing how they could locate themselves, if there needs to be a class action, are they positioning themselves, are they ready? That is what I believe the essence of the forum or the discussion is. That in other words, this legal service provided by lawyers should evolve at the pace, if not ahead, of developments as we see them. I also noted that, take for instance, even the capital market. How many of us are not staying far away and expecting that unless and until there is litigation that we can participate? Whereas in fact, because as was mentioned, you have different disciplines that overlap and interface with each other to develop our economy. Lawyers should take the initiative and find out or learn more and specialize, because gone were the days when we could be jack of all trades. If we are going to compete favorably with other countries, I believe even at now is the time to catch them young, which is the 0 to 5 or 0 to 7 years, for you to begin to think on the area of specialization that you would focus on, and then become the master of that area. The thrust of government, I'm inclined to believe, would touch on welfare issues. They are proposing to pay 5,000 to people, I think, per family, for those who are not able to help themselves. There are going to be legal issues that will emerge from that. Are we thinking about it? Are we positioning ourselves? What is the law as it is now? What legal service can we provide? The infrastructure law has always, you have a commission, it's always been there. But how many lawyers are featuring in the issue of construction? Now that houses continue to fall, to collapse, and a whole gamut of issues in that department. I believe that these are areas, some of which existed before, but which are expanding because of shift and development and economic reality of our time. The young lawyers should look and begin to position or locate themselves and specialize. Interestingly, I mentioned lottery because it's an area of the law that I doubt that people think is serious. And yet, it's a gold mine because other governments and other jurisdictions use that to even fund major projects. But the legal intricacies are so much that you really need to understand and specialize to make it work and become a leader in that sector. I think, and I would advise also, that young lawyers should from day one look at the possibility of teamwork, because gone were the days when you can provide all the expertise. So one of the things I know I thought I should also draw attention is that in identifying those legal practice areas that are emerging, you could also look at the demographics, because there is a shift. It could be in gender. I'm sure the women here, there's so much that's going on to protect the interest of the female and even vulnerable persons. I had mentioned the internally displaced persons before, who are, for this purpose, are also vulnerable. There are legal services that could be provided to support these initiatives, and I believe it also presents an emerging practice area. Finally, I would say that bearing in mind the pillage of resources, the corruption, and the impact it has had on our development, the young lawyer particularly should recognize or try to find the opportunities that are emerging from these difficult scenarios and become a master in the specialized or preferred area. For as long as you remember, however, that the ethics that you adhere to defines you as a lawyer. So no matter the area, the basic knowledge should be enhanced and improved at all times. But your creativity to even provide services, support services in areas which had probably not been explored would ensure that you're protected first from other encroaching professionals. Because what we're seeing now, which I believe will be discussed under, possibly under in another forum, is that we now have a lot of encroachment, other professionals doing things that providing services that hitherto were strictly for lawyers. And of course, like I said earlier, because of access to information and even other jurisdictions that are now encouraging non-lawyers to own firms and appoint lawyers to work for them because it is seen as a business. That means the mindset of the young lawyer, and in fact the mindset of us lawyers, should shift for us to have an entrepreneurship mentality. Not that you lose the ethic of the profession, but within the subject matter that you are a master of, you also know that really law is a business. Thank you.
Thank you, Nella. After 2 yellow cards, I wanted to flash the red one before you now stopped yourself. Thank you. The next speaker is J.S. Okutekba, Senior Advocate of Nigeria.
Well,
yes, please proceed.
Mr. Chairman, I do not know how to talk sitting down, so I seek leave to stand up. Thank you. Well, thank you, Mr. Chairman. The topic I was asked to talk on, and I got notice of it only on 18th of this month, while I was on the road, and I was called by the LOA, is titled Catching Them Young, Generational Shifts and Possibilities for a New Law and Order. Now, I said in paragraph 2.0 that I tried to understand the meaning of the term I was given to speak on, and I almost got lost. I understood perfectly the meaning of catching them young. What is the meaning of generational shift and possibility for a new law and order? Does this term presupposes that young lawyers needed to be caught at their infancy in the profession and to be given proper training and opportunity to achieve the most desired national development? Does this term also assumes that the old generation of lawyers have failed and failed us for there to be a generational shift and possibility for a new law and order to emerge? After trying hard, I came to the conclusion that this term was chosen in the light of the general theme of the conference, lawyers and national development. That we need to catch the young lawyers at their infancy in the profession and give them good foundation is a duty we all owe them as senior lawyers. It is also important to underscore the point that we seem to be drifting as lawyers in our responsibilities to the young members of the profession. And the young lawyers appear to be at the sea and lack directional focus in the trip of life in this profession. No doubt, we need generational shift for there to be possibility for new law and order. We so much desire. Young lawyers must be and should be the vanguard of national development, and to be the agent, the new generation of lawyers must be willing and ready to take advantage of every opportunities available in the legal profession. After all, law is an instrument of social change, and the young lawyers must make themselves available to effect that change. For me, the change we need is in you, and until you are willing and ready for the change, no change can take place in you and within you. In talking to us on this theme, we must be ready to admit that there is a feeling among generation of young lawyers that the old generation of lawyers are not doing enough to carry them along. And the young lawyers feel marginalized and unwanted. They feel rightly, in my view, that no opportunity is given to them by the old lawyers. Some lawyers are refused opportunity on account of so many reasons. It could be reason of sex, family background, the grade he or she made from the university, or even the law school. And it could even be the reason of experience. You walk into a chamber, you are denied opportunity to realize your potential. Then how do we catch them young? The older generation of lawyers must be ready to give the younger lawyers opportunity to learn and practice the noble profession. The older generation of lawyers who are in practice have a role to play in creating the conducive atmosphere for the young lawyers to thrive. And you can just give them a file, let them go to court and try their luck. When they learn hard, they will come back and they begin to change. The old lawyers must demonstrate and instill the core values of the profession in the young lawyers, working with them. The core value of the profession, which is anchored on honesty, integrity, professional respect, and courtesy, must be demonstrated by the older generation of lawyers, while allowing the new wigs to craft the future based on current realities. It is my view that as senior members of the bar, we must give opportunity to the new generation of lawyers to learn on the job. Thus, the old generation of lawyers need to, one, give opportunity to lawyers in their offices or law firms, to insist that young lawyers must have experience of any number of years before giving them opportunity or before employing them, or that they must have first class from university or law school before engaging them in our law firm, is an example, with due respect, of refusal to catch them young. They may not have the requisite experience, but give them the opportunity if they have potential and the willingness to come in and learn and develop themselves. You can only see their potentials if the opportunity is given to them to showcase themselves. Two, we must mentor young lawyers by taking direct interest in their progress and development while in our offices. As old generation of lawyers, we must take the young lawyers along with us, pay their practicing fees, pay for their stamp and seal, take them to conferences, and pick their bills. In those days, senior lawyers pick bills, but these days, some of us look the other way around. Let's pick bills of the young lawyers. Be friendly with them and make them feel that they can be greater than you. Take them out for lunch and dinner. Develop the habit of taking them to activities of the bar. Encourage them to attend bar functions. Challenge young lawyers by giving them file to go to court. I know of some offices that young lawyers only go to take note. For 5 years, they don't go to court. Challenge them, give them pep talks from time to time, and imparting core values of the profession in them. Create a forum where you allow young lawyers to air their views, even in your office. Make room for their failures and imperfections, and play the fatherly role or motherly role, as the case may be. Consistently show them that the future is theirs, and they will have to live up to it or fail it. Imbibe in them the spirit of hard work, commitment, and dedication to duty and professional callings. As old generation of lawyers, we must show the light in our conduct before the young members of the bar. As senior members of the bar, our conduct must be impeccable in our dealings with our colleagues and with courts. As lawyers, we must show the young generation of lawyers in practice that litigation is not a game of cleverness or smartness. As Nikitobi put it, and I quote him, litigation is not a game of cleverness, smartness, or tricks. It is not a hide-and-seek game where one of the parties in all cleverness and smartness takes ambush and waits with all acrobatic dexterity for opponent to fall into trap and get him thoroughly harmed or destroyed. Litigation is not a game of chess where one of the parties attempts to trap the opponent's king to obtain victory. On the contrary, litigation has an inbuilt system. Well, I'm receiving a yellow card, but I said for you as a young lawyer, in conclusion, as a young lawyer, you must be determined to be different and do things right, no matter the cost. You must choose the path of honor and integrity in your practice, whether you are in government or in private practice. You must be the only one that will be noticed for your hard work and industry. And when an assignment is given to you finally, you will have to do it well and study hard to even surpass your expectation and the expectation of your principals. I thank you all.
I thank Mr. J.S. Okutepa, SAN, for his presentation. I see that you connected with a lot of the young lawyers, especially when you started saying, pay their this, take them to conferences. When you get back to, I know you have offices in Abuja and Makurdi, you will expect to receive 100 applications for employment. Please offer all of them who apply jobs. Thank you. The next speaker is our past General Secretary. I was just asking Ella, why did I not see SAN behind his name? Because I know that he's in the new group of senior advocates who will be sworn in this September. So put your hands together for Muyiwa Akimboro. He also wants to stand.
Thank you very much, sir. Sorry, I'm not very used to speaking from the kind of comfort I find myself. My paper is titled, Bye to the 90s and Welcome the 21st Century Lawyer. In introduction, I'll say, the 21st century has ushered in fast-paced development and changes in practically every area of human life and endeavor, the legal profession inclusive. It has been described as the century of dramatic changes, accelerated development, and fierce competition, which has essentially changed the perception, methodology, approach, as well as tools, as well as work tools, virtually rendering the old ways obsolete. Given the changes today, this paper is aimed at highlighting 5 points, which I believe, if adhered to, will assist the today lawyer to become a 21st century practitioner. Before we proceed, the question I firstly want us to ask ourselves individually is, why are we lawyers? This question is very important because a lot of influences, there are various reasons why we are lawyers. Is it the parental influence, the peer influence, the glamour, social status, wealth, success, or power? We need to know our why. What is your own why in becoming a lawyer? For me, growing up, I've only wanted to be one thing and nothing but that. I've forever wanted to be a lawyer. Looking back, the question that takes my mind is whether knowing why I want to be a lawyer or my why and not adequately equipping myself was not equal to gambling, gaming, and walking into the dark alley blindfolded. In all human endeavor, there is luck, grace, and the God factor, all of which could account for the semblance of rightness of my then decision. Unfortunately, these factors are not equally available to all at the same measure. While being grateful for my modest professional growth, it took me quite a number of years to get to where I am. My conviction is that you don't have to wait that long. If I knew then what I know now, it would not have taken me this long myself. I know you'll be interested in what I know now. They are not much, just 5 short points. I will start with the first one, and that is, you start with the end in mind. Starting for us as legal practitioners is at the point of our core. This is also the point that our why is most relevant, as the step next we take out of the call ceremony have a lifetime defining effect. We all stepped out, each to a desired line. Some baristas, some solicitors, and that is why our why sets in and begin to mold us to our set states at the end. Is it the glamour, is it the riches that come with it, the respect of the society or the whole, that people hold lawyers? Or is it your desire to be one of the best, if not the best, to assist in attaining justice, which is the last hope of the ordinary man? Or to be renowned in a particular aspect of the law, to enhance development and deepen the law for common good of all, to be a jurist of repute, incorruptible, fearless and independent, or to be an instrument of positive social change. When you step out of the call to bar ceremony, all with your left foot, wrong mindset, warped outlook, restlessness, ultimate success will be a challenge. A smart starter will start with the end in mind, will arrange his priorities right, will be a visionary, will look towards making a difference. He will not do things as usual. Will be committed, professional, responsible, dependable, cautious, hardworking, and act in a proper way at all times. There have been a lot of debate about the length of time a young week need to spend in tutelage, or the relevance of tutelage at all. For me, every bird has the right to fly, but the hurdle is the path to follow. Listen to me and listen good. There is no shortcut to success. Mastering procedural represents 60%, and knowing the law itself guarantees you 20% success, while other factors like perseverance, personality, comportment, presentation, passion, commitment, etc. accounts for the rest. A practicing lawyer gets better by the day, and by more and more appearance in court. Where do you get this kind of exposure, if not from tutelage? I would say a word is enough for the wise. The end for a professional career is getting to the top, like in advocacy, adorning the silk. If the end is the peak for you, know now, there is no trick. It's simply no pain, no gain. Know how to capitalize your needs and dwell less on your wants, because at the end of the day, it is your need that will fuel your why to propel you to the heights you desire. The second point I will want to share with you is acquiring new skill and the know-how. We are in a fast developing world. Economy, technology, and the law are developing at very rapid speed. Think of it. Let's take a pause. If 15 years ago, you were told that there will be a small device that you can move around with and make telephone call, you will probably answer, possibly. But if the discussion goes on to say, this small device will not only work as a telephone, it will send emails, take pictures, scan documents, conduct live chats with audio and visuals inclusive, organize your office, transfer funds, file cases in court, send you reminders, count your steps as you walk, read your heartbeat, tell your location to the whole world, and more. Definitely your answer will have been different. Most likely, stop kidding me, or yeah, right. This is just a little graphic illustration of how fast the world is moving in technology. In all this fast-paced development, no single step can be taken without the involvement of a lawyer. There are franchising agreements to be entered into, multiple licensing agreements, patent issues, copyright issues, distribution agreements, and technology transfer issues, dispute resolution issues, virtual businesses issues, and even how to share the profit in that illustration is even a legal issue. This is just the tip of the iceberg of opportunities out there. A smart lawyer should have a nose to spell out opportunities 100 kilometers away. There are many other well-profitable areas of practice: sporting law, sustainability and environmental law, aviation, maritime, competition law, policy, legislation, and arbitration. Many of us are aware of these opportunities out there. But awareness, is that enough? While it is important to be able to identify new skill gaps in the profession, a smart lawyer will go further to identify how to fill them. As a young lawyer, I implore you not to rest on personal development, as the world is moving at a fast pace. So is competition in the profession becoming stiffer. To be able to fill the skill gap that are open and will continue to open, you need to keep yourself abreast of development. Try and develop yourself in your own area of interest. Build a reading culture. Buy, borrow book to read. It is only stealing them that is illegal. If you can afford it, pay for and go for continuous specialized legal training. A lot of information are hard there on the internet. Ping less, chat less, Facebook less. Do less negatives and engage in more positive use of your time. There are many libraries out there that are free for you to use, and many articles and research works in several developing areas you can learn from on the internet. Gradually build your own library. All the big and rich libraries you see in established offices were not built in one day. They are products of discipline and long sacrifice. The richness of your library goes a long way to tell about your commitment to your profession. There is a saying that rich people have big libraries, poor people have big televisions. The third one is a habit versus your goal. A life without goal set can aptly be described as floating and living on chance and opportunities. Everybody needs to have a goal in life. Setting goals drives us. It transmits us from the laid-back mode to the focus and go-get-it mode. Goals are good to be set. It makes us more organized, result-oriented, focused, place priorities rightly and on the front burner. One thing with goals is management. It needs to be properly managed so that it will not transmit to overdrive, bringing recklessness, carelessness, corner cuttings, and dangerous risk-taking. Blindly focus on goals could lead to grievous consequences. Reckless pursuit of goals can lead to disaster. To drive your goals home safely, you need to work on your habits. Don't only work on goals, work on and create good habits to achieve them. There are no shortage of people that have goals in this world, but a shortage of people with positive habits. I don't know how to summarize this, but I will want to say that apart from the third one, which will tell you about how you transmit yourself from a no action state to an average action state and to a massive action state, and you also bear in mind that in the profession, people are watching you. In your office, don't think people are not taking note of your punctuality, diligence, and commitment to work. In the profession, do not think colleagues and observing your association with people, your conduct in and out of court, your disposition with colleagues, are your words your band? Are you into sharp practices? Are you honest in your dealings? Do you take undue advantage of colleagues? All these are relevant in creating your habit. Also, the association watching you, the judges are watching you, and all that. Know that in everything we do in life, every day is for the thief, one day is for the owner, and the chicken always comes to roost. The fourth one I want to tell you about is, I'll share with you, is that your network is actually your net worth. Don't forget that don't forget that those that you meet on your way up, you always meet them on your way down. When you talk about networking, the first thing we have in mind or we think about is hustling for clients. But your networking goes beyond that. It includes your structure you put in place to ensure effectiveness. Those include your structure of your practice, staffing, equipment, reference materials, welfare issues, and including familiarizing yourself even with the courts. In socializing, know that as a lawyer, you are required to socialize with dignity. Socializing in a dignified manner helps you in building a network. But note that as a clear warning that your socializing with the judiciary must be decent and in accordance with the professional ethics. On the other hand, membership of professional corps, professional association, alumni association, and so on may be good ground for networking, provided that the activities and the expectation are not inconsistent with your status as a legal practitioner. Don't compromise your standard, even for the most prominent of your networks. It will always come back to hurt your network. And finally, I want to talk about your mindset. Again, you must have, compared to the fixed mindset, you must have a growth mindset. I think the papers are already on the website of the Young Lawyers Forum and the MBA. I will urge us to avail ourselves with the papers on the internet. Thank you very much.
Thank you, Muiwa. I had to grant you an extension of time because I was also learning a few things from your presentations. Thank you. Thank you. Please put your hands together again for him. The next speaker is Uwa Ohiku. Did I get the name correct? From Jackson Eti Edu and Co. of Lagos. You will stand. Thank you. I know a woman who said, I won't take this lying down. And she got up.
Good evening.
Causing problem everywhere.
Good evening. Good evening. Okay, that's better. I just want to thank the four earlier speakers. You know, they did a fantastic job. I had prepared something which talked a lot more about the opportunities in the area, the core area of practice for me, which is intellectual property. But you know, 2 days ago, I just was thinking over it, and I said, you know, I'm going to deviate totally from what I had prepared, and I'm going to talk to the young ones about those soft skills that are often overlooked. The Leonard Silpagbowulu, did I pronounce it correctly? Mentioned something when he started. He said, in school, emphasis is on the technical skills and all of that, and we overlook other things. And the other three speakers after him have spoken about those other things. And I really enjoyed the last speaker. Thank you very much, sir. I want to talk about those other things that from the side of us, the older lawyers, and I dressed down for this occasion so that I will appear to be like a young lawyer. I did that deliberately. I wanted to connect with the young lawyers. I didn't want to frighten you when you know how many years I've been called to the bar. Anyway, what are those things that can set you young lawyers above the rest? what are those things that we are looking for? Being on the side of an employer of people, of labor, one thing that we're finding out that is really standing out is that we are seeing a lot of very brilliant graduates, very brilliant, but there's certain things that are missing. We're seeing people that can't even write properly. We're seeing people that don't understand how to behave. We're seeing people that lack etiquette. And all of these things. We're seeing people that are not ready to take responsibility. We're seeing people that are not putting themselves forward when tasks come up. We're seeing people that are not ready to sit at the table. We're seeing people that are not ready to put their hands up. All of these things can set us aside or apart from the normal to the outstanding. These are the things I would like to just talk about briefly. Let me start with what they call etiquette. This is a topic that is so dear to my heart, and I'm going to use two examples. I have a cousin who owns a law firm as well. He's a learner, he's a silk in Lagos. And do you know he had a lunch with some of his clients in Abuja here. And he had one of his senior lawyers join him for that lunch. And he didn't know how to use cutlery. He didn't know how to use cutlery. And you've got this can ruin a business opportunity. You've got people, you've got clients, and they are not local clients who can overlook certain things. They are foreign clients. They've got the white skin, and they are there. And the cutlery is there. He didn't know what to do. So what did he use to eat the rice? He used a spoon. At a formal lunch. These are things, eventually, my cousin had to kind of exit him out of the law firm and exited him into a company to be an in-house counsel. As funny as that sounded to me then, it was a serious matter. We're seeing it happen. I was at lunch earlier on where lunch was, and I was just observing. And I saw it all play out. So etiquette, and I'm going to divide etiquette into two. Etiquette in the workplace. I'm not sure, I think one or two speakers talked about it, possibly the last speaker. Etiquette in the workplace. Understand where you are working. Understand the values. Understand the principles of that place. Understand the culture of where you are working. Understand what mutual respect means. Understand what the so-called the seniors, the owners of the business, understand what they are looking for. Understand that you have to show what I believe the learned first speaker said about show the entrepreneurial skills. Because when we are looking down the road, we are looking for people that are going to take the business forward. Am I saying the truth or not? We're looking for who will take the business forward. When we are employing, I did a course 2 years ago, and since I came back from that course, I told my partners, I said, the next person I'm going to employ, I said that person is going to go through the eye of the needle. Because I learned, after how many years, I learned that when I'm employing, I should be looking for the person that is going to take the business forward. I should be looking for the person I can hand over the practice to. That wasn't what I was doing before. So that changed totally my idea of who I'm going to employ. So it's not just about, oh, we have gone to school. It's not just about we're lawyers. It's not just about, oh, I'm smart. It's about bringing the smartness, doing what we need to see. The last speaker talked about Facebook less, chat less, Twitter less. We find that happening a lot. There's too much distraction whilst we're at work. We want to mentor. I mean, the topic I was given, like I said, I put it aside, also talked about opportunity to mentor. We put ourselves forward to mentor. We want the young lawyers to be receptive to mentoring and not see mentoring as, oh, you know, she's too high-handed, he's too high-handed. What's the big deal? It is a big deal. We are in the profession of the learned. I always tell people, others are educated, lawyers are learned. We are in that profession. Let us enjoy the profession. There are things that are, Mr. Timekeeper, I apologize. You need to let me know if I have 2 minutes. You need to let me know when I have 2 minutes.
You have taken one of the 2 remaining.
Okay, I mean, I've talked about understanding authority. That's another thing that, honestly, we are looking to the younger ones to understand how authority works, how to bring yourself under authority, how to understand that in the line of authority, you are going to be there at the top somewhere and you expect somebody to also understand how authority works. I've talked about raising your hand. I've talked about sitting at the table. Sitting at the table, it's a bit more gender sensitive. We find that, well, I see that a lot, that at meetings, I walk into meetings and I see that the men are kind of spread out and the ladies are all kind of recessed. No. My dear ladies at the bar, they say there are no ladies at the bar. Sit at the table. Gentlemen, sit at the table. Sitting at the table means volunteer to be seen. There's nothing wrong with being ambitious. Be ambitious. Go for it. Be responsible. Be hardworking. Like I said, the earlier speaker said practically everything. Thank you so very much for the opportunity.
Thank you, Ohiku. The next speaker is well known to all of us. He's an Ibadan boy, just like some Port Harcourt boys here. Please welcome Shehu Abimbola of Prime Solicitors. Shehu, you have 10 minutes.
Thank you, Leonard Silk. Good evening. I have a short slide. If I could have that up, please. Okay. Great. I was asked to speak from the perspective of starting a law firm and the generational shift and possibilities associated with that. I tried to look at these from 3 perspectives. First of all, we start from the first generation firms, and then the second generation firms, and then we ask ourselves what the next generation law firm should be looking like. But before we get there, after the fanfare of being called to the bar and the celebrations of it, young lawyers are like young guns with bullets without practice. It's like a soldier out of the Nigerian Defense Academy. He has all the knowledge upstairs, but he has never shot a gun, and you load him with an AK-47 and a lot of rounds of ammunition. He's likely to want to test it whichever way he knows how. And that's how we are as young lawyers. And that's what underscores some of the things that the earlier speakers have said about mentorship, about training, about pupillage, and I will not want to go over that. It's a stage where you learn to sink or to swim if we are left to ourselves. It's also something that branches of the Nigerian Bar Association would have to take up in the respective jurisdictions to have strong and committed mentorship programs for new weeks. Now, talking about generational shift with respect to the law firm or starting a law firm. Pre-independence, the state of affairs was such that we had a number of lawyers in Nigeria who are UK-based, and because we were a colony of the British government, there were many lawyers from there who were here as well, practicing here. But then, we also had the first crop of Nigerian lawyers trained in the Inns of Court, returning home, and most of them set up their firms almost immediately. But then, the model adopted was suitable to the time, was suitable to the market that they were coming into. At that time, firms were relatively small. Many were even sole practitioners, and some were sole proprietors in terms of they had a few associates, but relatively small. But there was deep knowledge, and they spent a lot of time developing their skills. Many times, I believe at that time, and what I'm speaking from a couple of research work I'd done when I was chairing the Law Firm Management Committee of the MBA, and I saw that many times at the time, a lot of older first-generation lawyers learned on the job. But today, you still learn on the job, but you need to come into your own law practice with some level of skill apart from knowledge. Then there were limited practice areas. The predominant practice areas of that time were chieftaincy matters, were land matters, landlord and tenant matters. If you read the All Nigeria Law Report, if you read WACA, like J.S. Okutekwa, he likes WACA, you would see that these were the predominant decisions of the time. Some criminal cases, some commercial matters, commercial leases from the few multinationals we had at the time. Moving from there, we should also recognize that a few of those first-generation firms actually pioneered international legal practice, much of which was on the West Coast, appearing in Privy Council, which was sitting across jurisdiction. But then came the second-generation law firms. The second-generation law firms basically evolved from scions of the first-generation law firms, whether biological scions or those who walked in the chambers of some of the old war horses. And what they brought into the practice of law or the law firm operations was that they developed new skills, they developed new practice areas. They introduced modern management structures in running a firm. It no longer was a principal who was principal litigator, principal solicitor, principal clerk, principal filing person, principal everything, principal accountant too. It became something that was shared. It became a more corporate structure. The second generation firms also introduced a more professional outlook. Succeeded in taking back a lot of legal service work from professional consulting firms. In the 80s, most of the big ticket commercial work went to Arthur Andersen, went to Price Waterhouse, went to Coopers and Lybrand. They were basically financial service accounting firms, but they all had in-house general secretaryship kind of operations. They had lawyers working in-house. And so many multinationals, oil companies would take the job to them, then they will farm it out to a law firm. And so we were on the tail end of the food chain, and the consulting firms took the big piece as middlemen. But these second generation firms took the brief directly from the multinationals, simply because they had demonstrated more skill, they had demonstrated a more professional approach to the practice of law. Then one thing that was introduced by the second generation firms was that they built the brand of the firm rather than the practitioner. In the first generation firms, you knew the lawyer. You hardly heard anything about the firm. The lawyer was the firm. But in second generation firms, you see that you hear more about the firm than the individual lawyer. And that's where the real concept of what a law firm is all about. We need to build our firms rather than just building ourselves. There's nothing, I'm not talking about professional development now. I'm talking about creating an image for the practice. When you create an image for the practice, you need to create an image for the firm. not just an image for myself. Otherwise, when that individual passes on or is away from the firm for a period of time by political appointment, what becomes of the firm? Nobody knows the firm. They only know him or her. And so that's something that we will probably begin to see more of. They also popularized the concept of legal practice to be run as a business and popularize the partnership model. In this generation, which I would take from the 21st century, are we thinking of a congested landscape for lawyers, particularly when we consider how many people pass out of our law schools every year? I don't know what the numbers are, but it suggests as if there is congestion. But I like to use the analogy of the birds. Chickens, ducks can fly, but there is a limit to how high they can fly. And by virtue of that limit, they compete for food with larger mammals that cannot fly at all, even though they can fly. Then you have other birds that can fly higher than chickens and ducks. But they also compete with aircraft and insects. So at the atmospheric level, they can fly. Then you have the eagle that can fly higher than everybody else. And it has ample space to do whatever it pleases. It can see further, it can plant faster, it can swoop for the kill and go and nest in the mountains where no one can reach it. What that simply means is what earlier speakers have said about specialization. Even in prison, there's general population, there's maximum security, there's death row. You could look at that by virtue of the fact that if you're in general population, you have a little space. Maximum security, you have more space. Death row, you're on your own. So there's more space. But that simply underscores the need for us to consider specialization as critical in terms of building or starting up a law firm. Vision is critical. You ask yourself several questions. What sort of law firm do I want to build? What area of the market do I want to service? What sort of practice do I want to have going forward? Knowledge and skill. I like to always talk about knowledge and skill. Knowledge, we acquire a bit of it by tutelage, by reading, and by the 6 years we would have spent in the university. Other types of knowledge you acquire by observation, by experience, by exposure. Skill is your correct application of the knowledge you have acquired. In soccer, all of us have knowledge of soccer, but the skills that are exhibited will determine whether you're a star, whether you're a warmer of the bench, or whether you are just an enthusiast that has no club. All of us are enthusiasts that have no club, but we have knowledge of soccer, but we don't have the skills. So we need to consider skills. They need to be different. Technology is what has made the difference. And I always encourage young lawyers that even though many of our seniors, the chairman of today, for instance, I know that they have managed to get a grasp of technology. But I can dare say that a 1-year-old at the bar that brings probably iPhone 6 to our chairman, if you have a competition as to how to operate it, we know who will win. That's the advantage we have as young lawyers in terms of the use of technology. While some of our older colleagues might have a way of relating with their clients, you can, with technology, go beyond. And there are many other things technology can do. They might have precedent by virtue of experience in their heads, by virtue of the things they have seen. But you don't have to cram it like they had to do. You can only look at Law Pavilion or Legalpedia, and you can do your research faster than many of the older practitioners who have to go to their old practice notes and go through the indexes before they can get the same results. Passion for excellence, opportunities will come. When those opportunities come, what do you do with it? If every other thing we have spoken about, every other thing other speakers have spoken about are put in place, when the opportunities come, that will be your launch pad. I want to emphasize the need for partnerships. Whereas the first generation firms could thrive at the time when they came into the profession, it was largely because the number of lawyers in Nigeria was limited. Now, there are a lot more lawyers. And I think the leverage that we can use as young lawyers to get a good start is to start as partnerships. A lot of times when we look at law firms springing up as kiosks, as small shops, it's simply because everybody wants to own their own thing. But the leverage that a twosome or a threesome would have if they come together and combine resources in every area will go further than if you were the only one starting it. In conclusion, I said that the desire to start a law firm is as important as learning how to keep it running profitably, even after it's been established. Managing a profitable law firm is a discussion for another day. Thank you very much.
Thank you. Thank you, Shaun, and thank you for applauding him. The next speaker comes from the firm of Ernst & Young, right? I cannot say, I don't know you, Mr. Linus Okeke. Are you a colleague? No, just sit down. I'm only trying to lay some foundation. Are you a lawyer? Yes, I am. Okay. Well, you know why I say this? At some point in my career, I came to know that Ernst Young had a multidisciplinary practice. Correct? And there were accountants there, there were lawyers there, there were estate surveyors there, there were engineers. I don't know if they've started hiring doctors as part of the firm. But this will be a very good opportunity. So please let us welcome our colleague, Linus Okeke of Ernst & Young, who will have 10 minutes. He also prefers to stand. Thank you.
Thank you, Session Chairman, and good evening, everybody. Let me just start by sharing my own little background in terms of how I got involved with this exercise. I was privileged to do my National Youth Service with the current National President of the Nigerian Bar Association. And about 2 weeks ago, he called me and said, Linus, I think you've done very well. You need to come and share experience with some of the young lawyers. Let's see how we can motivate them. And when I reflected on my days of youth service with him, what intrigued me was the fact that I was given the opportunity to argue an interlocutory application against a very senior lawyer. And that particular experience resulted in my younger brother getting admission to study petroleum engineering at the University of Benin, because the exercise was against, so the client of the firm where I was doing my youth service happened to be a lecturer at the University of Benin. Why do I share this experience? It's just in tandem with some of the eminent senior and other lawyers have mentioned. But in my own case, I think along the line, I branched off after my youth service and my master's degree. I started by working in the firm of Arthur Anderson, and I had, I think the last speaker, when he mentioned the fact that along the line, lawyers had to take legal services back from, they'll be looking for the senior advocates of Nigeria. They will be looking for the young lawyers. But what do you then need to do as a young lawyer in order to be sure that you are there? I think for me, the first thing is know yourself. And what do I mean by know yourself? What are you good at? Yes, you have been called to the bar, you're a lawyer, no doubt about that. But some of us may have flares for advocacy. Some of us may have flares for maybe legal drafting and all whatnot. Secondly, invest in yourself. To my mind, I think gone are the days where first degree and being called to the bar will be enough. At the minimum, you need to have a master's degree. And master's degree is not just about going to go and study LLM general law. Look for an area of specialization. When I did my own master's degree, one of the areas I majored in was criminal law and criminal policy. And in the year 2005, one of the partners of Arthur Anderson Stroke, which later became KPMG, told me and said, look, Linus, we want you to champion the establishment of forensic services. And when he mentioned, I said to myself, this is an area that will be in tandem with the course I studied at the master's level.
and I was privileged to be the person that established the first practice, the first staff of the unit, so to speak, and the rest is history. So the point I'm making is that we've heard about maritime law, cybercrime, and all whatnot. What are you doing? Are you developing interest in those areas? And developing interest is not just about reading about those areas. You need to show that that you need to be reckoned with. For instance, writing articles in those areas so that when people are looking for people they want to consult, they do that. At times, you find out that international firms, not law firms, international companies that are looking at engaging lawyers in Nigeria, they will normally ask me, for instance, who are the lawyers who can engage in this particular area? And what will come to my mind is not about who is a senior advocate, I can tell you, but who is conversant. My team will bring in our own investigation knowledge and, again, accounting knowledge. Today we are talking about what? There's what is called transaction forensics. It's not all about drafting agreements. You can sit and look, and one of the things you can be advising the client on is, look, if this agreement goes through and is signed by parties, what are the likely dispute areas? It's better that the client is proactive in addressing those potential dispute areas than waiting for those areas to crystallize. Then everybody becomes reactive. There's also the area of cybercrime. There's what is called contract compliance, which is basically assessing the extent to which the parties have complied with their contractual obligation. It's a hot topic today, especially with international companies. People have talked about being IT savvy. I'm not going to go into that. Please beware of fast lane. And I don't want to dwell much about that. Mind your language. Many people, again, we are learned people, we're supposed to be learned. But some people, even the way they write, you begin to imagine whether this person is actually a lawyer. And one of the greatest gifts that lawyers have, or one of the greatest edges that lawyers have over other professions is what? Ability to write. That is one thing lawyers are respected for. But I've seen many young lawyers who make some silly mistakes with due respect. I've seen some CVs where if you look at it, it's like the person is using BlackBerry language to prepare a CV. Somebody is sending you CVs for consideration. The person is using a BlackBerry language. Meanwhile, maybe I've met somebody and the person said, look, I have someone who is looking for a job. He says, ask the person to send me CV. The young person doesn't know me. He's sending you CV and the language he's using as if he's your mate. These are little things that matter a lot. Of course, you should also welcome the unexpected. Above all, you need to hold yourself accountable. Don't blame other people for anything that happens. Hold yourself accountable, and if you do that, I believe that the sky will be your limit. And in conclusion, I would like to give us this quotation from a writer called Jordan Furlong. And he says, distant, detached lawyers are relics of the 20th century. The market no longer wants a lawyer who is only half a person. And my poster to each and every one of us, the young lawyers, are you only a half a person lawyer? Thank you very much.
Thank you, Linus. You didn't tell us about multidisciplinary practice again. You don't want to get into trouble. Well, we have our last speaker coming. When he said BlackBerry language, I remembered a text from my daughter, TTYL. I said, what is this one again? And I asked her, she says, Daddy, you are colo daddy. Colonial mentality. Please welcome Onofio Kluk, who is our last presenter. I hope I got the name right. Member of the House of Assembly of Akwa Ibom State. Please, clap for him now.
Thank you very much, the chairman of session, co-panelists. Good evening, members of this noble profession, most especially my generation. Sir, let me report myself. I was called to the bar in the year 2010, so I am a young lawyer, sir. So most of the presentation this evening are for my benefit, sir. So And I want to permit me to say, sir, I want to stand because I want to show a good example of a young lawyer who takes his rules of professional conduct very serious. It wouldn't be nice for me to sit down in a panel that has senior lawyers. So, sir, that's why I have to take a bow once more, sir, before my learned senior and SAN for that matter. And I have been set up too by members of the Young Lawyers Forum. They placed me among people that have title SAN at the end. And I was the only one without a title. I wish they could have added SAM, maybe Senior Advocate of the Masses, since I represent the people in the House of Assembly. But that's on a lighter note. I was asked to speak on the topic, Catching Them Young, Generational Shift and Possibilities for a New Order. And I had to look at it from the perspective of the general theme of this conference, the 2015 Annual General Conference for the NBA. Let me thank the Nigerian Bar Association for giving me this opportunity, and then the Young Lawyers Forum for equally extending this invitation to me. The general theme of this year's conference, Lawyers and National Development, aims at depicting the fact that a vibrant and engaged legal profession is indispensably relevant in attaining a healthy, vibrant, independent, and robust national development. The outcome of the 2015 general elections brought both a change in Nigeria's political ecosystem and a fresh challenge to professionals in the country. As the chief drivers of many developing economies globally, industry professionals now have new opportunities to look out for in today's Nigeria. These opportunities arise because there are now very new roles which experts must play towards actualization of the promised change in government. In my opinion, the need for skilled Nigerians to adopt a new attitude and a new approach towards national development is key to the successful realization of the proposed change that we are talking about. And then we cannot deny the fact that in this new dispensation, in the new order, that the young professionals in this noble profession have a greater role to play to sustain this order and then bring about the changes that we have been advocating for. Now, in spite of the multitude of challenges that we currently face as a nation, truth be told, our democracy is taking root, possibly much faster than many may have envisaged. The questions, therefore, are, how do we fit into and function gainfully in the process as young legal practitioners? What parallels can we make of the older generation of lawyers and today's very dynamic practitioners when it comes to national development? How do we make our age, our network, and our youthful energy count? If indeed we function better in stable constitutional democracies, then today's Nigeria offers us some new potentials which we must take advantage of. It means there will be sectors which will demand our critical expertise inputs as young lawyers. It means new visas have been opened, as we as a younger generation of lawyers must leverage to drive democracy in the country within our various capacities. With your kind patience, I wish to have you reason with me on some thoughts which I have to share on how we can get involved in the building of our nation. A number of you may already be asking quietly, can our input make any difference? Do I even have a stake? Well, as one who has spent the last 8 years holding a public office in Nigeria, both stipendiary and non-stipendiary, I can tell you that we do have a big role to play. The survival or sustenance of the emerging new order largely depends on us. And when I said non-stipendiary in 2008, I was the Speaker of Nigerian Youth Parliament. And then in 2011, I was elected into the House of Assembly for the first time. And I'm on my second missionary journey there. Now, the current administration has expressed believable interest in sectorial reforms of the Nigerian economy. Steps are slowly being taken to fulfill this promise. The president has also said that the fight against graft will take an unprecedented turn. Now, I want to probe their mind with these questions. How then, and in what manner, can we young lawyers take up a role in today's regenerating Nigeria? Our obligations. One way I believe will very strongly fast-track the reformation process in our country is for us to make it as part of our obligation as young lawyers to engage in research, which will make data available for our policymakers. Research here should not be limited to law. There must be a spread to other policy areas like economy, security, education, health, and etc. To this end, I advocate the birth of a policy think tank from this forum. Our country's legal practice is in dire need of a dependable data bank, one which will provide services to critical sectors, as well as provide dependable information, ideas, and knowledge. And in this respect, I want to thank the Nigerian Institute of Advanced Legal Studies for the great job they have done. And we must, as young lawyers, take the benefit of the continuing education programs of that institute to equip ourselves with the knowledge we need in today's world. We cannot talk about creating new opportunities without making available information as the first-hand instrument for empowerment. Deep, broad-spectrum research is the way to go for every young lawyer who is interested in tackling a social problem. A lot of legal issues abound today in Nigeria which remains very much unaddressed. For example, in telecommunication, the convergence of media have thrown up unresolved legal and ethical issues which the traditional legal and regulatory framework cannot address. Before now, we never used to have issues of legal framework